One of the things under American law, and even in the Navajo Nation, is you have to use legal theory to get to how and what you are after. In the business world, normally under American law, people do not have duties to one another and obligations. So all these people, I don't have a duty to give them $10, right? The way you create them, if they sold me something, is normally you would do it under a contract. You would enter into an agreement. And that expectation under the legal doctrine is when you enter into a contract, you give it legal effect. What a contract does is it allows you to resolve your disputes. If you have a dispute on this contract, you can go to court on it. Right? But in the case of the Navajo Nation, the United States, or the states, the sovereign entities, they are cloaked with this thing called sovereign immunity. And if you enter into a contract, the expectation of both parties is if we get into a conflict or a dispute, we can go to court to resolve our dispute. But if somebody is clothed with sovereign immunity and raises that as a defense when they get dragged into court, then the other party doesn't have a legal remedy. So because of that, most folks, when the dollar amounts are pretty high, they will ask you, in a lot of cases, to say, if you want me to lend you this money, or if you want to, if I'm going to bring this amount of dollars to the Navajo Nation, I'm going to ask you to waive immunity, so in the event we have a dispute, I can have legal recourse. We can go before a judge, and we can present our facts, and I might get some relief. So that's basically what a waiver of sovereign immunity is.
3 points to make on top of that. One about the coal ash, 2 about the final obligation, and 3 about what was done in order to get us here. Take that point first. A great deal of work was done in assessing the environmental impacts of the mine as it sat, including the coal ash that was already been deposited there underneath about 10 feet of soil. We used the resources of the due diligence team as well as Navajo EPA. Steve, that's I think you might be around. And we're very comfortable that the ash was stable in place underneath something that would retard the water from going down. 2, going to go to who's responsible for final reclamation. So under the coal supply agreements, the participants, the owners of the power plant, are obligated to fund the final reclamation as it's required by the Office of Surface Mines. So that's not an NTEC and definitely not a Navajo Nation liability. And then finally, if we are wrong and there is some impact and somehow it's not caught by the during the final reclamation process, US EPA and Navajo EPA retain the right to go out if later on there is some unforeseen and unforeseeable impact. So there are essentially three levels of protection. 1, we've analyzed where it is today, feel very comfortable, there's no environmental liability. 2, if we're wrong and there turns out that in the future there is, the Four Corners Power Plant participants pay for it. And 3, if somehow they get around that, the US EPA can go after them as well.
Let me put it in English. I believe the right place to start is within the Navajo Nation court system. When you ask us to waive that law, you're basically telling us as counsel not to trust and believe in our system, court system. I, for one, resent that. That is preventing them from using the outside court system once. Who knows? court system to say, okay, Navajo Nation, pay this amount?
Are we setting aside all our sovereign immunity, which doesn't stand well with me? I know to do business you have to waive some sort of sovereign immunity, but not all of it. The public is saying that a lot of mines from the 60s, 50s, 70s are not being cleaned up. Yet the Attorney General Tsosie, you conveyed to the council that it is being cleaned up, which I'm glad to hear. Who is paying for that? Is that under also a bond for them cleaning up, or who has cleaned up all these mines?
What kind of dispute would we have? What kind of dispute would they have with us? In any event, we have to utilize the insurance. And that's, as I understand the legislation, that's the reason why we're being asked today to waive sovereign immunity. Is that the event the insurer, the people that issues the insurance, have an issue with us, what would that be?
Issue that Zurich could have in the performance of the application would be if, for some reason, you guys are not performing under the contract, and through conversation and dialogue, they can't get comfortable where NTEC is going. NTEC is not performing according to the manner in which they think the coal mine should be operating, and they choose to exit and cancel the surety bond. They have a right to do that. Bonding and insurance companies are not like bank relationships. They're similar, but they're not exact. So it's a continuing relationship, but either party can terminate at any time. And so in the event that the surety does not feel comfortable, cannot get comfortable, and they generally do go back to NTEC or the nation, they ask questions, they try to get comfortable. If they cannot do it, and they choose to terminate, if that bond is not replaced in the time frame required by the contract, then the utility has the ability to forfeit that bond. They have the ability to call on the entire amount, $300 million, at which point the surety has to respond. They have no choice in that matter. They agreed when they issued that bond that they will do that, okay? They will not choose that course of action lightly. It will have to be a situation where they have really gotten to an impasse with NTEC, and therefore they choose to terminate that particular relationship on that.
Well, there are probably different ways in which Four Corners Power Plant could be out of compliance with its contract with NTEC. One might be a situation where they would not want to produce as much coal as they said they would. So in that particular case, we have minimum coal purchase requirements that they must make. And in the event that they don't, or some of the ways in which that works out, but essentially they are able to recover those liquidated damages, if you will, through their rate making system with the Arizona Corporation Commission. So in effect, certain pieces of the coal supply agreement have protections for NTEC, guarantees, if you will, minimum purchases, which is backed up by a regulatory payment system through the different regulatory agencies which govern the areas in which those utilities operate. If I may, I'll also refer to Paul Frye for additional clarification.
I just have one clarification, and that is that in all of these situations, NTEC on the one hand and Four Corners on the other is protected by what's called the force majeure provision. So that if there's a natural disaster or a court order or something else like that that prevents NTEC from delivering the coal to the power plant, that's not an event that's going to trigger a requirement under this bond. That's accepted from this bond requirement. The other thing that I'd like to say is that there are a whole lot of steps that will have to be gone through before there's a dispute under the provisions that the Marsh people have explained to me. There has to be 1 million tons, I believe, of coal stockpile. There has to, and so that if we, for some reason of our own fault, quit producing coal, that stockpile is going to continue to allow them to produce power. There's a 30-day cure period, so that if we're negligent, and we certainly shouldn't be, we've got BHP, same miners that have done a great job for 50 years, going to continue to do the mining. But in the event that something of our fault stops the mining from occurring, we have a 30-day cure period in addition to the stockpile to get things back on track. So my own view is that we would have to almost deliberately sabotage the mine before any of these bonds would be called upon. It would have to be a decision of the Navajo Nation Council to put people on the management committee to sabotage the company.
And the performance bond. So in the event that APS doesn't perform, what guarantees does the nation have concerning?
We have a minimum take provision that goes through the end of the contract in 2031, and that's 114 trillion BTUs, I believe, is the number. We have that minimum take guarantee, and if they fail to buy that coal from us without one of these force majeure events, these uncontrollable events, then we have a right to go against them under the same arbitration regime.
Is that NTEC's rights are joint and several, so they don't have to go against APS and each of the other participants for their share, but instead they can go after any one of them, and it's up to those participants to allocate the share. So as long as they aren't all gone and in bankruptcy, there will be, and they're big utilities, there will be somebody out there for NTEC to go.
Because I saw signs out there say leave our PTF alone, that's them from the trust fund. Will the trust fund be collateralized for this effort? Is that part of the plan or the general fund dollars? I think we need to know that.
To respond in part to several of the comments, what is our job here as presenters and agents? And it's to get the best information to the decision makers, delegates, so that you can make an informed, dispassionate decision. So I noticed the same thing that Mr. Tsosie just mentioned, hands off the permanent trust fund. In general, the permanent trust fund isn't implicated at all in this transaction. So I looked actually at each of the placards out there and wrote down what they said, because not only should the Nation Council be well informed, I think all of the people who urge you to vote one way or another should be well informed. So let's go down that list. Hands off the permanent trust fund. This transaction, the purchase of the coal mine and entering into the coal supply agreement, has nothing to do with the permanent trust fund. Next placard had 3 things that Navajo money was being paid for, was being used for. 1, $3 million for the due diligence. Correct. I don't know if it's $3 million, but it's a lot of money that was paid for due diligence. So that's correct. $3 million or so Navajo money was used to make sure that we had the best information going to you as decision makers as possible. $85 million of Navajo Nation money going to purchase the mine. Not true. The money that's going to be used to purchase the mine is the income that NTEC is getting from selling coal. And there is a scheme of how that money is paid to BHP to retire the note. There is a note for $85 million, but the note is between NTEC, Navajo Nation, and BHP, and we will pay for the mine through the revenues that we get by selling coal. Next thing on that same placard, $130 million of Navajo Nation money going to buy these bonds. Not true. The bonds are going to be paid again by NTEC through its normal operations. And the people who are actually funding that on a year-to-year basis, the premiums for those bonds, is BHP. That's something that we negotiated with BHP after we learned the council didn't have a whole lot of taste for putting that money directly into NTEC. So that is not true. Next placard said, there is risk and uncertainty in this transaction. True. This is business. There is some risk and some uncertainty in every business. The question is for the decision makers, does the due diligence work and the other information that you have tell you that this is a prudent risk given the principles and the values that are implicated here, including 900 jobs, $60 million or so per year to the general fund, roughly a third or a quarter of what you get to run this government. But yes, there is some risk, there is some uncertainty, but we think it's fairly small, quite minimal in fact, because we have BHP running the mine for the next 3 years with the same people that have run it for the last 50, and we will be making sure that any substitute operator will be somebody as good as BHP, and they will probably want to use the same employees that are there now. Okay, next one. We're just buying an old car. All right. Question is it a junker or is it a classic? This old car, we think, the due diligence team found that it's a well-maintained vehicle. It's been operating profitably for the last 50 years. There's no reason to believe that it won't be operated well for the next, at least until 2031. And we've got 100 years of coal reserves there that we still, as NTEC, want to see if we can transition from dirty coal to clean coal and get out of the dirty coal business. Finally, there was a placard out there that said, essentially, speak up, let your voice be heard. Amen. That's why everybody's here. And that's all coming on to you as a decision maker. But our job is to present you with accurate information. And some of that information has to be in executive session because we are playing a card game with our commercial partners / competitors. And we don't want to play that card game with our cards showing